Good day, everybody. I hope you're all doing extremely well. I can't believe we're already on the June training session for 2021. And since it's June and we are properly in the midst of the third wave of COVID, I am in fact comfortably at home as we are trying to keep everybody safe and healthy. So that's the reason for the slightly different look that I am in. But let's get straight into it. Today's session, I'm actually very excited about. The reason for that is I have a very proper real life case study that courtesy of one of my favorite agents, and you guys know I say that to absolutely all the agents, but this is actually a matter I helped with about 2 or 3 weeks ago. So thank you very much. The agent will know exactly who I'm talking about. Thank you so much for sharing the timeline and the information around this case study. It's a perfect case study when it comes to renewals, what can happen, what shouldn't happen, what does actually happen sometimes. So thank you so much for sharing the information. And for everybody else, I really hope you enjoy it and you do learn from this particular case study. So let's get straight into it. As these days too, I have beautiful slideshows for us, which keeps me on track as well. So what we're talking about today is renewals. When we get to renewals of fixed term lease agreements, it's something very important. And if we handle this incorrectly, it can effectively blow up in our faces so impressively. So I'm very happy that we can go through this theory again when it comes to renewals, but then also have a discussion around the practical application of renewals. So before we start, let's just get ourselves into the renewal headspace. So we have a very different situation when we talk about renewals in agreements where Section 14 of the CPA applies and in situations where it doesn't. So let's quickly touch base again on when Section 14 of the CPA will apply to a lease agreement or not. Please remember, if you want the flow chart on when it applies or when it doesn't apply, please visit our website, sslr.co.za. On the resources tab, there is a downloadable flow chart for you on when the CPA applies or not. But for the purposes of this training session, let's touch base quickly. The first question you ask is this agreement a fixed term agreement or is it a month-to-month agreement? If it's a month-to-month agreement, Section 14 of the CPA will not apply to the agreement. If it is a fixed term agreement, but there is a natural person in the agreement, so be that the landlord or the tenant, so it's not a company, if it is a natural person, so it actually has a name, so it's not a juristic entity on both sides, so both the landlord and the tenant are juristic entities, there is one natural person, then Section 14 of the agreement will apply. Yes, even if that natural person is the landlord. What I wanted to say just now, and I interrupted myself, was a juristic entity, remember, under Section 14 of the CPA, is a company, a closed corporation, a trust, a body corporate, a partnership, as well as an association. So if you have a natural person in a transaction in a fixed term agreement, Section 14 of the CPA will apply. If Section 14 of the CPA does apply, it's crucial for you to be aware of the rules and regulations around renewals of this particular kind of agreement. And I have Section 14 of the CPA for you on the slides, but I decided to get straight into the case study because theory is, fun and stuff, but if we can't see it in practice, it makes it a little difficult. Now, in this particular case, what's important to know is the landlord is a natural person and the tenants are natural persons as well. So this is very easy to see. It was a fixed term agreement. Both landlord and tenant are natural persons, not juristic entities. And for that reason, Section 14 of the CPA does apply to this particular lease agreement. Let's look at the content of the lease agreement. So Clause 8 of this specific lease agreement says that the lease agreement commences on the 26th of June 2020, terminates on the 30th of June 2021. So for everybody's benefit, I am recording this today on the 9th of June 2021. So we are heading towards the end of this lease term, but you will see on the dates we're talking about, this is actually very relevant because it's almost like 40 to 80 business days is a very long period of time. And then suddenly when you get towards the end of a fixed term lease agreement, suddenly that 40 to 80 business days time window seems to shrink into almost no days at all. So please always make sure you note these things up front in your file for your tenant and landlord already on commencement. So make notes and diarize your 40 to 80 business days, and please rather start communicating on day 80 rather than day 40. You will see this was in fact the case in this case study. This lease agreement says it will commence on the commencement date. It will terminate on the termination date. Fantastic. And it now turns to the CPA. And this is the reason why I started off recapping on the application of Section 14 of the CPA. This particular lease agreement, however, it sets out some requirements in the event that this lease agreement is subject to the Consumer Protection Act. That is if. And now it goes to say when it will apply. So I highlighted here something in yellow under 8.2.2. Unfortunately, because this is in fact incorrect in law, it says the CPA will apply if the landlord is a natural person and the tenant's a natural person. Lucky, I'm happy with that. But now it says if the landlord is a natural person, but the tenant is a juristic person, the tenant that's a juristic person must have an asset value or annual turnover under 2 million rand at the time of the conclusion of the lease. I will show you Section 14 specifically says regardless of asset value or annual turnover. So the truth is this is a unnecessary part and it just causes unnecessary confusion. I just wanted to point that out because I am quite sure clauses like this does appear in lease agreements sometimes, and that might confuse you amazingly, but I'll show you Section 14 of the CPA just now, which makes life much easier. And then 8.2.3, where the landlord is a juristic person, irrespective of the landlord's asset value or turnover, true story, and the tenant is a natural person. Yes, I do agree, but it's not. It's regardless. It's irrelevant whether the landlord or the tenant is the natural person. Section 14 of the CPA will apply if either one of the parties is a natural person, and I will show you once we get to the actual wording of Section 14 why I am saying that. Then Section 14 of the Consumer Protection Act shall apply to the lease agreement. This is very relevant because if we then go to the to clause 8.4 of the lease agreement, it now deals with how renewal or termination will work in a case where Section 14 of the CPA does in fact apply to a lease agreement. And what it says is no more than 80 and not less than 40 business days prior to the impending termination date, the landlord will give a notice to the tenant informing them of the impending termination date, and will let them know which material changes will be relevant to the transaction if the agreement continues beyond the termination date. And then on the termination date, the lease agreement will automatically continue on a month-to-month basis subject to any one of these material changes referred to in clause 8.4.2, of which the landlord has given notice to the tenant. And unless the tenant expressly directs that the landlord must terminate this lease agreement on the termination date. So this is the content of the agreement that we are working on. Pretty standard. You will note in most lease agreements, and this is the content of these clauses. In your lease agreements, the lease agreements based on the TPN leaseback lease, you will find these clauses in clause 5, 6, and 7, dealing with how our termination works, how it works, that it carries on a month-to-month basis, and what happens if the tenant does not respond to this notice. I will get to that after we've done the case study on practically what I recommend is the better and easier ways of doing it so we can protect ourselves. Okay, so this is the content of the lease agreement. Let's quickly pop into the theory. And so I'm moving back away from the case study now, but we need to see the law to be able to apply the law. So this is section 14 of the CPA, not the full section. I only have section 14.1 and section 14.2 for the simple reason that section 14.3 and thereafter is irrelevant for the purposes of this particular training session. Now I've highlighted this section 14, and this is one of the reasons why I always say I never train anybody on my opinions. I simply read legislation and then train you on it boringly so, or at least when I highlight things in yellow, at least it's less boring. And now is the moment where I'm going to need my glasses. Otherwise, I'm going to start trying recalling legislation from the top of my head, and that will be a sad situation. So section 14.1 says, this section does not apply to transactions between juristic persons, regardless of their asset value or annual turnover. Now, why I'm saying it, section 14 of the CPA will apply, even if the landlord is the natural person, is because of this word between. Between means there must be a juristic person on both sides of the agreement. So both landlord and tenant must be juristic persons for section 14 to not apply. And that clearly says, regardless of their asset value or annual turnover. So for the purposes of section 14 of the CPA, there's no need to make any mention of asset value or annual turnover. There are other parts of the CPA that might apply, like the cooling off period, section 16, section 48, dealing with unfair provisions. But I think it's so unnecessary to deal with that in a lease agreement that, to be honest, I feel quite comfortable not to make any mention of asset value or annual turnover in the context of a lease agreement. And then we move to if a consumer agreement is for a fixed term. So remember, this now doesn't apply to month-to-month agreements at all. It only says if a consumer agreement and a lease agreement does form part of the definitions of this act under consumer agreement. So a lease agreement is a consumer agreement, and if it is for a fixed term, then the term may not exceed the maximum period as the minister prescribes, and at this stage it's 24 months, obviously unless the landlord can demonstrate financial benefit to the tenant, which is why we simply record that in writing in the lease agreement. But it's irrelevant for the content of this training session. Despite any provisions of the consumer agreement to the contrary. So what we're saying is we don't care. The Act says, I don't care what the content of the lease agreement is, despite the content of the consumer agreement. This is the rights that the consumer will have. The consumer may cancel the agreement upon the expiry of the fixed term. This is very relevant because I will show you now under 2C, 14.2C, that this obligation is on the supplier, so the landlord, to make contact with the tenant 40 to 80 business days prior to the impending termination date. If he doesn't and the tenant vacates on the termination date, he is allowed to do so without any penalty or charge, because the landlord did not make contact, and the tenant does have the right to cancel the agreement on the expiry of the fixed term, or at any time by giving 20 business days. That's irrelevant for the purposes of this training. It is, however, a training session on its own, early cancellation and then the early cancellation penalty. Then the supplier may cancel if the tenant is in breach, also irrelevant for the purposes of this training. Relevant to this, however, section 14.2c says not more than 18 and not less than 40 business days, guys. Business days, very important. Before the expiry date of the fixed term of the consumer agreement, the supplier must, the landlord must notify the consumer. The landlord must notify the tenant in writing or any other recordable form. Ignore that, please. Let's stick to in writing. Of the impending expiration date, including a notice of any material changes that would apply if the agreement is to be renewed beyond the expiration date. So be that for 2 or 3 days, month to month, or for a further fixed term, the landlord must notify the tenant of these material changes. What would these material changes be? That would be increased in rental. Anything else that would be material, for instance, say the body corporate rules changed in the meantime, and now the tenant is no longer allowed to keep a pet. That is material to the agreement, and it is important to notify the tenant of this in this 40 to 80 business day time period. Or the other options available to the tenant in terms of paragraph D. Now let's look at paragraph D. On the expiry of the fixed term of the consumer agreement, it will be automatically continued on a month-to-month basis, subject to the material changes of which the supplier has given notice, as contemplated in paragraph C. And then the consumer, the tenant, can direct the landlord to terminate the agreement on the expiry date, or agree to a renewal of the agreement for a further fixed period. So this is what the law says. The law says 40 to 80 business days prior to the impending termination date, the landlord must make contact with the tenant, or the agent mandated on behalf of the landlord must contact the tenant and say, listen, Mr. Tenant, okay, here's how it stands. Lease agreement is coming to an end on the 30th of June, 2021. The landlord doesn't want to renew, so we can terminate the agreement on that day. Sorry, lekker, find another place, you're going to love it, and may the force be with you. Or lease agreement's coming to an end on the 30th of June, 2021. The landlord's happy to renew, but the landlord is going to increase the rental if you do stay on, or if you do decide to renew the lease agreement. Sorry. And then the tenant has the choice to react to that. The tenant can either say, lekker, I'm happy, let's renew on the proposed terms the landlord gave, or yes, my counter proposal. If the landlord then rejects the counter proposal and says, well, sorry, we didn't agree to a renewed term, then the lease agreement will come to an end and the tenant must vacate on the termination date. Or the parties agree to do a renewal, that can be in the form of an addendum or a new lease agreement, whatever the case might be. On that topic, please keep in mind, guys, if you are moving to a new lease agreement, and I do know a lot of you watching this training video is either in the process of moving or have recently moved over to the TPN leaseback lease in your particular group. If you are moving to a new lease agreement, guys, please keep in mind that on every renewal, please sign a new lease agreement. Otherwise, we end up with those lease agreements from 19 Toet still on our books instead of updating it with new lease agreements. There's no requirement in law to do that, but it's just some practical advice. If the lease agreement is exactly the same as it was last year, there's no need to do a new lease agreement, then you can do a renewal addendum. So I hope that that's just some practical advice there. So let's get back to our case study. What are the facts here? The lease agreement was due to terminate on the 30th of June 2021. So I quickly went back and I counted, and our 40 to 80 business day time period lies then between the 3rd of March 2021 and the 4th of May 2021. Please go back and count, and if I miscounted, please pop me a WhatsApp. I would love to see that. Usually when I count, I get another attorney to count with me to make sure I've got my dates right, didn't miss a public holiday or something. But in this case, I didn't have someone with me, so I had to count twice. I'm quite happy with these days. And please keep in mind, it's business days. And in May, we have a few public holidays on the 1st of May. And then also in April, obviously, we have the 27th of April being Freedom Day. And then we also have Easter weekend, so Family Day and all those public holidays there. March the 16th, we have, what is that again? March the 21st, we have March the 16th is my nephew's birthday. That's not a public holiday, but it could be. He's a pretty cool kid. But March the 21st is Human Rights Day. So it's important to keep this in mind. Public holidays, we count every working day, not Saturdays and Sundays, and not public holidays. So this is the window, the communication window that we have with regards to renewals, the 3rd of March 2021 to the 4th of May 2021. All right, let's see what happened. On the 8th of February, the agent sent an email to the tenants saying, hey, tenants, spoke to the landlord. Landlord is in a bit of a pickle. He needs to increase the property, the rental to 22,000 Rand a month, but he is happy to accept 20,000 Rand a month from you because we like you and we're used to you now. Happy to do 20,000 Rand a month, but the landlord actually wants 22. Then on the same day, on the 8th of Feb, the tenant responded to the agent and he said he's very happy with the 12-month lease. However, I find this quite curious because the agent actually said for a second year, and then this the tenant just said for a further 12 months. So clearly, this tenant just wants to get, you know, he's using the right terms. And if things like this happen, I'm already like, okay, you are clearly just trying to set the record in a specific way. So let's just have a bit of a heads up here. Then he says, no, traditionally increases were 10%. And he had a major salary cut thanks to COVID. And with all of this in mind, the landlord must please consider dropping from the 20,000 Rand a month to 19,000 Rand a month. Okay, then nothing happened. And I think this is the concerning part because let's quickly look at the dates. That communication happened on the 8th of February. But what we just saw is the 8th of February was too early. It was earlier than 80 business days. Our 80 business days was only on the 4th of March, 3rd of March. And so this was a little too early. But then on the 8th of April, which is now fairly in the proper time period that we need to be in between the 3rd of March and the 4th of May, the 40 to 80 business day time period, the tenant said, I'm just touching base with the agent. The lease is coming to an end in a few months. Are we now going to accept the 19,000 Rand a month? 2 days later, agent responded and said, thank you very much for your email. However, the landlord is not willing to accept 19,000 Rand a month, will only accept 20,000 Rand a month. I want to pause here. The tenant does not have the right to dictate any terms to the landlord. The landlord and the tenant is currently negotiating. there's no reason why the landlord must accept the 19,000 Rand a month. The landlord may say, listen, we didn't reach settlement, we didn't reach consensus on what the terms of the renewed agreement would be, and for that reason, we're going to cancel. They're negotiating at this stage. It's very much okay. We are allowed to do it. So now agents saying, nope, 20. The tenant comes back and he says, no, sorry, I am sticking on the 90. And then the agent goes back and she says, nope, we are going to have to stick to the 20,000 Rand a month. The poor landlord can't afford anything less. I think something important to note in these messages, and obviously I was personally involved in all of this throughout communication with the agent. The agent at no stage did not communicate with the landlord, with the tenant. The agent had constant communication with the landlord, and the landlord was very slow. And I think it's important for you as the agent to keep in mind, if that happens and the landlord is slow and not getting back to you with instructions quick enough, just let the tenant know. Just tell him, listen, I'm waiting for the landlord to get back to me. It does also help to reinforce the situation in the tenant's mind that you as the agent has no say in these negotiations. You're simply acting on behalf of the landlord. Anyway, and now we see these people are also having a baby, and they really don't want to vacate. What happened in the meantime is, still, by the 21st of May, now we're outside the 20 business days, the 40 business day time period. Remember, we only ran up to the 4th of May. Now we're already past it. We're outside of the 40 to 80 business day time period for these negotiations. And now the tenant and his wife are willing to accept 19,000 Rand a month, except that was never on the cards. The poor agent says, as I mentioned on the phone, the agreement is going to terminate. You didn't accept the terms of the renewal, and for that reason, it's not renewing. We didn't agree to a renewal. You're going to have to vacate the premises by the 30th of June. Rightly so. Then, I just put this in for fun for you to read, because this is so classic, the kind of things that we are seeing every day. And now the tenant is responding to the agent. This is now the agent's fault, right? I'm saying that tongue in cheek. It really wasn't. It's always at this point where the poor agent is the middleman and in trouble with both the landlord and the tenant. And actually, the agent in this particular matter, there's a few things that I think we could have changed to make it better, but wasn't really acting in any way to a level where I'm thinking, oh goodness, the tenant, actually the agent made a mistake here. But now the tenant is very sad and so disappointed, and they're having a baby and they can't move, and they're not going to pay anything more than 19,000 Rand a month. And unfortunately, she can't move because she's going to be 30 weeks pregnant by the 1st of July. So it's a very sad situation. And by now we're already on the 23rd of May. And now the tenant is clearly indicating that they're not planning to vacate. So let's fast forward a little bit to the 25th of May. And the agent is saying, listen, the landlord was nice enough to allow you to pay 20. We've already signed a new lease agreement with a second tenant to take occupation on the 1st of July for 22,000 Rand a month. Unfortunately, you're going to have to vacate. You can't stay. And further to the communication today, also, and now the tenant, the agent is saying, okay, we're going to talk a little later, but the truth is we already have a lease agreement signed for a secondary tenant to take occupation on the 1st of July. It's in this moment where the agent obviously called me frantically and said, Silna, what do we do now? And I said, well, the problem is this tenant, the termination was done correctly. But what I'm seeing here is we will be able to commence eviction on the 1st of July. But the problem we have is if there's a new lease agreement signed, that tenant must be notified because they won't be able to take occupation on the 1st of July because these people are clearly not planning to vacate. So back and forth, and I must say it was one of those where I just prayed with the tenant, with the agent to say, oh my goodness, now we need to get these people out. And we just need to hope that they're going to vacate. And luckily, they did then say they're not going to renew the lease agreement on the price that the landlord wanted, because it's an 11% increase. And it's very sad that the relationship is now ending, and they did actually agree to vacate by the 30th of June. So I'm still sitting here presenting training saying this all went very well, and I hope it does. I hope they do in fact vacate, but we're not there yet. So I don't know if they are in fact going to vacate. So I can't give you the end of the story of the case study yet. But practically from what I am seeing, the parties did agree that the tenant will vacate by the end of June and the new tenant can take occupation. What could have happened? We could have had two tenants, because if the original tenant, the first tenant, then said, I am really sorry, I am not going to vacate the premises, or worse, if the agent wasn't very clear on the communication and said something like, when the tenant said, I want to rent for 19,000 Rand a month, if the agent accidentally said, you know what, that's perfectly fine, let me just confirm with the landlord, that would have been sufficient for that first tenant to make a case that the renewal agreement came into effect. But now there was a second lease agreement signed, and that tenant that has to take occupation on the 1st of July, if that tenant can't take occupation on the 1st of July, he will have a damages claim against the landlord. And if it was due to the incorrect communication and the incorrect handling of the situation by the agent, unfortunately, the landlord will have the right to claim those damages from the agent as well. It's a scary situation, so please be aware of this. If you have two tenants, the secondary tenant in this situation, who was of the intention to take occupation on the 1st of July 2021, if they can't take occupation and the landlord didn't notify them already, let's say by the 25th of May, that they can't take occupation, they will have a proper claim against the landlord, which is a scary situation. Or at the same time, if the lease agreement didn't terminate and there was no notice given or no clear communication that the landlord is not willing to accept the 19,000 Rand a month, well, like I just said, it might be deemed that agreement came into place. So a lot of things could have happened, and it could have gone very bad with loads of damages claims. So be aware of this and be very careful. Luckily, in this case, I think it worked out pretty well. Let's look at the renewal process, what it should have been. The landlord need to talk to the tenant 40 to 80 business days prior to the impending termination date. If the landlord wants the lease agreement to terminate, it doesn't want to renew, it's a simple notice, guys. Day 80 prior to the impending termination date. Dear Mr. Tenant, I hope you're well. Lease agreement is coming to an end on the 30th of June 2021. The landlord is not of the intention to renew the agreement, and accordingly the agreement will terminate and you need to vacate by that day. Please let me know how we can arrange a key handover. Easy as that. If the tenant does not respond to a notice, what happens? So in your lease agreement, you will note, we've made provision for this. We said, Mr. Tenant, if you do not communicate and sign a new agreement or sign the renewal addendum 30 business days prior to the impending termination date, it will be deemed that this agreement is going to continue on a month-to-month basis. Why did we do that? Because if the tenant then does vacate, the landlord has a damages claim against the landlord for that month's rent, and you can hold the deposit for that. And this is for that tenant that's like back and forth, back and forth, back and forth, and nothing actually happens. He doesn't sign the agreement, nothing actually happens, and the landlord is stuck in a position where he doesn't know what to do. And have a look at your lease agreement. If you have a clause like that, fantastic. If you don't, make sure you get something in place so you can confirm what the position would be. If you don't have a clause like that and the tenant doesn't respond, unfortunately, in terms of the Act, he may terminate the agreement on the expiration date. So he may vacate and the landlord will then lose that damages claim. And there I have load shedding, and my timing is perfect because I am actually done. I am so sorry for this, but I hope we got the whole one, and I'm going to enjoy my life in the darkness now, but you're more than welcome to ask me any questions if you have anything.